Hearing the appeal Totel Limited against Commissioners for Her Majesty's Revenue and Customs.
My lady, my lords, I'm Michael Firth. I appear on behalf of the appellant. My learned friends Mr. Swift and Ms. Eddy appear on behalf of the respondent HMRC. As the court will have seen from the papers, this case concerns the EU law principle of equivalence, and it raises three issues relating to that principle. The first issue is, for the purposes of a rule requiring prepayment of disputed tax before an appeal will be entertained, are appeals against VAT assessments similar to appeals against assessments to income tax, corporation tax, capital gains tax, and or stamp duty land tax? We say that they are similar for that purpose. The second issue, where there is more than one similar domestic action, is the principle of equivalence satisfied if any one of those similar domestic actions is treated in the same way, even if other similar domestic actions are treated in a way that is more favorable? We say that the appellant is permitted to draw a comparison with the more favorable action unless that involves unusual or exceptionally beneficial rules. The third issue is whether the Court of Appeal was bound by an interpretation of EU law contained in the House of Lords decision in Stringer on the meaning of the most favorable proviso, which I'll explain what that is later. We say that the Court of Appeal was so bound and it impermissibly departed from that binding interpretation. The structure of my submissions will be, subject to the court's interjections, that I will briefly explain how the issues arise in the present case. I will secondly deal with a preliminary point on the question of whether there is less favorable treatment which HMRC have raised in their case. I will then take the court through the key cases as quickly as I possibly can. Fourthly, I will make my submissions on similarity. Fifthly, I will make my submissions on the effect of another or other similar domestic actions being treated in the same way, including the no most favorable treatment proviso. And finally, I'll make my submissions on the binding nature of the House of Lords decision in Stringer. First, how the issues arise. As the court will have seen from the papers, the underlying tax dispute concerns HMRC's assessment to input to VAT in 2006 and 2008, denying input VAT. Those assessments were appealed, and when the assessments were appealed, that engaged the machinery within the Value Added Tax Act 1994, Section 83. And I would like to show the court that legislative provision because it is central to the appeal. And that can be found in tab 38, page 1101.
Is that the electronic number?
It should be, my lady.
Yes. Tab 38.
Yes, my lord.
Which volume is that?
It's the third volume, I think. No, second volume. Third volume, my lord, I'm sorry.
Well, my tabs only go up to 21, then second volume.
It's third volume, my lord.
Third volume. Right.
The appeal against an assessment for the court's information is made under Section 83, subsection 1, paragraph P for Papa. And we see at the beginning of Section 84, references in this section to an appeal are references to an appeal under Section 83, subsection 3. Subject to subsections 3b and 3c, where the appeal is against a decision with respect to any of the matters mentioned in P, it shall not be entertained unless the amount which HMRC have been determined to be payable as VAT has been paid or deposited with them. If we then skip to 3b, in a case where the amount determined to be payable as VAT or the amount notified by the recovery assessment has not been paid or deposited, an appeal shall be entertained if A, HMRC are satisfied on the application of the appellant, or B, the tribunal decides, HMRC not being so satisfied, that the requirement to pay or deposit the amount determined would cause the appellant to suffer hardship. So, in other words, your appeal will not get off the ground, it will not be entertained, unless either you pay the disputed tax or you demonstrate hardship to HMRC's or the tribunal's satisfaction. If the assessment had instead been an assessment to income tax, corporation tax, capital gains tax, or stamp duty land tax, there could be absolutely no question of the tax tribunal refusing to entertain the appeal if the tax is not paid, or for any other reason. There are some rules on postponing collection of tax pending an appeal in the context of those income tax, capital gains tax, corporation tax, SDLT. But postponement of collection of tax is a different matter to refusing to entertain an appeal. And I'm going to come on to that in a moment because it's relating to the question of whether there is less favourable treatment.
Is it different in its effect on the taxpayer?
It is, my lord, and I'll show you that in literally a minute, my lord. So a person may receive two assessments at the same time. One, denying expenditure net of VAT for income tax purposes. The other, denying the VAT element of the same expenditure. The reason for the assessments could indeed be exactly the same, that the expenditure was not for business purposes. The law is that the appeal against the VAT assessment will not be entertained unless the tax is paid or hardship is demonstrated. The appeal against the income tax assessment will be entertained without payment or without any other hurdle being surmounted. My submission, in a nutshell, is that treatment breaches the EU law principle of equivalence. If I may just quickly show the court how the Court of Appeal decided this in two paragraphs. And we're in the Appeal Bundle, tab 7, page 105. And we can see, please, at paragraph 47.
Say which page?
105, my lord. So the judgment starts on page 95, but the paragraph I'm going to show you is on page 105. It's paragraph 47, my lord, if that.
47 in the Court of Appeal.
Yes, my lord. So this is in the heading, Reasons for Dismissing the Appeal, subheading, The No Most Favourable Proviso Applies. And at paragraph 47, I would accept that the equivalence principle shares the same jurisprudential root as the equal treatment principle, but that does not mean that it has all the same incidence as that principle. The jurisprudence of the Court of Justice shows that it is open to a member state to apply any available set of rules which are already applied to similar claims to an EU-derived claim, provided that an EU-derived claim is not selected for the worst treatment. No one suggests that is the position here. So that was the main basis of the Court of Appeal's decision. But there was a secondary basis, and we can find that, please, on page 108, paragraph 59, which is that the Court of Appeal said, the equivalence principle does not have the effect that VAT has to be compared with other taxes. It follows that the prepayment rule is not impugned by that principle. I will come back to the Court of Appeal's reasoning in more detail later, but just so the Court is aware how this issue was decided below. And then an issue that wasn't raised by HMRC below, but is now raised in their case, is whether there is less favourable treatment at all. As I set out in paragraph 3 of my case, there are two separate issues. First, whether the tribunal will entertain your appeal. In other words, will it go anywhere? Will the tribunal issue directions for case management, for witness statements, for listing? There's a separate issue, which is whether HMRC can collect the tax whilst there is an ongoing appeal. So two separate issues. Will the appeal be entertained? Can HMRC collect the tax whilst the appeal is ongoing? The position for VAT purposes is that your appeal will not be entertained unless you pay the tax or prove hardship. That's section 84. I've just shown you that. Proving hardship does not stop collection of tax. There is nothing that stops HMRC collecting the tax in the meantime in the VAT legislation, even if hardship is proven. Instead, if you want to stop collection, you have to argue that the debt is disputed on substantial grounds in the winding-up court. And I can show you very quickly a case on that precise issue, which is Totel in tab 6, page 305.
Could you give me the MS number again, please?
Sorry, my lord?
The page number?
306, my lord.
306, thank you.
Sorry, 305. If I could just ask the court to read to itself paragraph 1 of Lord Justice Voss's judgment, because that sets out what is happening in that case. Now, it is not expressly stated in the judgment that hardship had been granted, but it is a necessary inference that it had, because the appeal was ongoing. It was being entertained. There had been a decision on whether to admit the appeal late, and if hardship had been an issue, it would have been decided then. And you can also see at paragraph 20 on page 308, third to last sentence, Judge Poole also gave directions for further hearing of the appeals against the dispatch assessments and made separate directions, order released on 12th of September 2013. The parties disagree as to when the appeals are likely to be resolved. So the appeals were being entertained, which means hardship must have been granted. Nevertheless, here HMRC were, in the winding up court, trying to wind up the company on the basis of those assessments. And the issue is whether the debt is disputed on substantial grounds, which requires grounds that are real rather than fanciful, imaginary, or contrived. So, in short, for VAT purposes, your appeal will not be entertained unless you pay the tax, but nothing stops HMRC collecting the tax in the meantime, except this defense in the winding up court.
And what happened in that case?
I believe it was held that there weren't reasonable or substantial grounds for disputing the debt, and so the order was granted. And you can see
well,
that.
Basically, it was whether the winding up court should defer to the view of the first tier tribunal.
Yes, my lady, but then issue 2, paragraph 56, the court itself decided it could decide whether there were substantial grounds, went on to look at the matter, decided there weren't, and made a winding up order, despite the fact that the appeal was ongoing.
Well, subject to the prepayment or pre-deposit rule and the hardship rule, there's no test of the merits to make an appeal to the first tier tribunal, is there?
No, that is the point, my lady. There's no test of merit for the income tax appeals, and there's no test of merit for the VAT appeals. That's why there's a difference in treatment, because as far as merit's concerned, there's no test, but for VAT, you have this extra hurdle, which is the pay the tax or demonstrate hardship hurdle, which is how we get to the difference in treatment, which is less favorable treatment. My lady, that does short-circuit what I'm about to show you, but I will show you the income tax provisions in any event. And that's behind tab 35 in the authorities bundle, page 1079. On page 1079, we have section 55 of the Taxes Management Act 1970. This governs the position for income tax, capital gains tax, and corporation tax. It also, as I will refer to later, governs the position for PAYE determinations. I'm not going to refer to it in detail separately, but the SDLT provisions are behind tab 31, page 1049, but they are materially the same in terms of the test.
I'm sorry, what was the page for that?
1049?
Thank you.
Yes. So, section 55, recovery of tax not postponed. This section applies to an appeal to the tribunal against B, an assessment to tax other than a self-assessment. Subsection 2, except as otherwise provided by the following provisions of this section, the tax charged by the amended assessment or where the appeal, amendment or assessment, or where the appeal is against a conclusion stated in a closure notice, shall be due and payable as if there had been no appeal. But then subsection 3, if the appellant has grounds for believing that the amendment or assessment overcharges the appellant to tax, A, he may apply to HMRC within 30 days, and B, may make an application for postponement to the tribunal. And then over the page, subsection 6, the amount of tax, the payment of which shall be postponed pending the determination of the appeal, shall be the amount, if any, in which it appears that there are reasonable grounds for believing that the appellant is overcharged to tax. So this has nothing to say about whether the tribunal will entertain an appeal. It is solely concerned with the issue of postponement of collection pending an appeal, and the test reached is the same as would be applied in the winding up court as you saw in Changtel. So the position reached, as my lady referred to below, a minute ago, on entertaining an appeal, VAT is subject to a restriction, but income tax and the other taxes are not. On postponement of collection, they are both subject to the same test. It's just that for income tax, you go to the FTT to make your argument. For VAT, you'll be up to the winding up court if HMRC choose to wind you up. So VAT appeals are treated less favorably because of this hardship hurdle. There is no corresponding upside that justifies or counterbalances having to prove hardship or pay the tax. One final point is that it should be noted that the tax tribunal has, in all cases, a power to strike out appeals where it considers that the appeal has no reasonable prospect of success. For your reference, and I won't take you there, it's tab 33, page 1058, rule 83C.
That applies to any appeal.
That applies across the board, my lady.
It'd be
So,
very surprising if it didn't.
so unmeritorious appeals can be struck out, whatever the nature of the appeal.
So basically your point is that everything's the same except.
Yes, my lady. So with that in mind, I do say there is less favourable treatment. It wasn't disputed below. It is disputed in this court, but that's my explanation for why it is less favourable. I now propose to take the court through the key cases, or the key cases I say they are, beginning with EDIS, which is tab 19, and begins on, the copy in the main authorities bundle doesn't include the Court of Justice judgment. So actually, if I could refer the court to Authorities Bundle Volume 4, which will have been on your desk this morning and was emailed and delivered to the court electronically yesterday. Hopefully within Bundle 4, you will find EDIS.
Well, it's all there is in Bundle 4.
Yes, my lady.
Yes. So that's the point. This is one, yeah. Thank you.
I got it.
Okay.
The facts. So for each case, what I propose to do is briefly set out the facts and then make my submissions on what we get from that particular case. And I submit we get 5 things from the EDIS case. The facts were that a claim in 1996 was made to recover annual payments of a charge to register a company that were paid between 1986 and 1992, those payments having been held to be contrary to EU law. So the claim was made in 1996, attempting to go back and recover overpaid registration charges to 1986, 10 years ago. National law provided for a 3-year time limit. The claimant wanted to rely on a 10-year time limit that was applicable to claims between private individuals for sums paid but not due. And that is how the issue of equivalence arose. So in my submission, we get 5 points from EDIS. The first is a general statement of the principle of equivalence, and that's at paragraph 34, which is on page 12.
Yes?
So the general statement is that the rules applying to actions in relation to EU law rights are not less favourable than those governing similar domestic actions, the principle of equivalence. The second point I say we get from EDIS is that equivalence implies a further principle that the rules apply without distinction with respect to the same kind of charges or dues, and that's at paragraph 36 in the first sentence. The third point I say we get from EDIS is that a member state is not required to extend the most favourable rules in its national legal armoury to all actions for repayments of charges. And that's the second sentence of paragraph 36. The court will recall that on the facts, this claimant had found a 10-year time limit, which is exactly the time limit it needed, in an action between private individuals, and was seeking to rely upon that particular time limit. The fourth point is that an action between private individuals is not similar to an action challenging the imposition of a charge or levy for limitation purposes. And I say we get that from paragraphs 37 and 39. And this proposition, I believe, is controversial and certainly is not how the Court of Appeal interpreted the case. So I will go into this submission a little bit more.
Say, where was that one?
So paragraph 37 and paragraph 39, my lord.
And how is it relevant to this case?
Because, my lady, the Court of Appeal and HMRC say EDIS is an application of the no most favourable proviso. I say, no, it isn't. What the Court is actually saying is that there's no similarity there. So, paragraph 37, community law does not preclude the legislation of a member state from laying down, alongside a limitation period applicable under the ordinary law to actions between private individuals for the recovery of sums paid but not due, special detailed rules which are less favourable governing claims and legal proceedings to challenge the imposition of charges and other levies. That statement is general in nature. It does not depend upon the rule that applies between private individuals being the most favourable rule. Put another way, the sentence would be the same even if the rule applying between private individuals was not the most favourable rule. The Court would still say, and did say, you do not get to rely upon the rules applying between private individuals when you're challenging the imposition of a charge or levy. And that is supported and indeed confirmed by the actual answer at paragraph 39. The answer to the second question must therefore be that community law does not prohibit a member state from resisting actions for repayment of charges levied in breach of community law by relying on the time limit under national law of 3 years by way of derogation from the ordinary rules governing actions between private individuals for the recovery of sums paid but not due, for which the period allowed is more favourable, provided the time limit applies in the same way to actions based on community law for repayment of charges as to those based on national law. So the Court isn't saying there, if the rule applying to private individuals happens to be the most favourable rule, you cannot rely upon it. It's a general statement that you just can't. You cannot go out and seek the limitation period applying to private individual actions. So EDIS is a case decided on the basis of lack of similarity. My fifth proposition based on EDIS is that in a situation where you don't have a similar domestic action, equivalence may still be breached if you single out community law actions. And that is the second sentence of paragraph 37. So in the first sentence of paragraph 37, having said there is no similarity, you can't draw the comparison between actions between private individuals and actions against the state to recover a charge, the Court then says, but things may be different or would be different if those detailed rules applied solely to actions based on community law. Then there would be a problem. And it goes on in 38 to say, well, there's no such problem on the facts. There was no third comparator in EDIS all you had was the private individual's action for which the time limit was 10 years, and then you had the actions that were treated in the same way at paragraph 38. There was no reference or no suggestion of some intermediate treatment for other actions.
And you say there's no intermediate treatment here? You've
Yes,
just
my
got those taxes where there is
Yes, my
no
lady.
prepayment requirement, and VAT where there is a prepayment requirement. There's
Yes,
nothing in the middle.
Nor it's, well, there's for excise duties, there's a reference to security, providing security, but no, the key submission is no, there's nothing. There's either the income tax treatment or there's the VAT treatment, and we have to prove hardship, they don't have to prove hardship. But just, if I may just linger on this second sentence in paragraph 37, because I know HMRC will place a lot of emphasis upon it, and I know the Court of Appeal placed a lot of emphasis upon it. They say it's authority for a fundamental proposition that as long as some other domestic action that is similar is treated in the same way, equivalence is satisfied. For the reasons I've already set out in relation to EDIS, that's wrong, but it's also not supported by any subsequent authority. We will not see this phrase again. It's also contradicted, I say, by the later authorities, including the decision of this court in FA Iraq. So those are the 5 propositions I say we get from EDIS. The second case I'd like to show the court is the Leves case in the Court of Justice. That's behind tab 21 in the authorities bundle. Begins on page 785. Facts of Leves were that we had a 2-year time limit on claiming arrears of pay where the lower pay was discriminatory. The discrimination claim was upheld, but the employer relied on the 2-year time limit. The comparison was drawn with ordinary breach of contract time limits and the time limits in relation to claims under the Race Relations Act. In my submission, we get 3 points from Leves. First of all, at page 797, paragraph 37, we get a statement of the principle of equivalence, which is the same as you saw in EDIS. And we also get at paragraph 42, a statement of the no most favorable rules proviso. The only thing that may be of interest is that in EDIS, the reference in relation to the most favorable proviso was to the generality of the legal system, whereas here, we're being referred to in the field of employment law. That's the only difference. The second point we get from Leves, and this is a point we didn't get explicitly from EDIS, is what to look for in terms of similarity, and that's at paragraph 43. This becomes part of a consistent line of case law that you must consider the purpose and essential characteristics of the allegedly similar domestic action.
Sorry, where is that?
That's paragraph 43, my lord. page 798.
My page numbers seem to be different. But
Is it 774, I think?
Is
what in the paper version? Oh, I see, yeah.
So, I mean, the Advocate General is behind the court in this case.
Yeah, thank you.
So, paragraph 43, consider the purpose and essential characteristics. The third proposition, and a very important proposition, is the statement that there may be one or more similar actions, and if there is, one must compare the rules of each. And that's at paragraphs 49 to 50.
So could you repeat the proposition you made there?
The court states that there may be one or more similar actions, and if there is, one must compare the rules of each to see whether they are more favorable. And that's borne out, I say, by paragraphs 49 and 50, and confirmed by the actual answer at paragraph 53. And I would particularly emphasize paragraph 50, if it transpires, on the basis of the principles set out above, that a claim under the Act which is brought before the county court is similar to one or more of the forms of action listed by the national court, it would remain for that court to determine whether the first mentioned form of action is governed by procedural rules or other requirements which are less favourable.
The first mentioned form of action meaning the EU action.
Yes, my lady.
Yep.
And then the actual answer, which is obviously the only bit that binds this court, in view of the foregoing, the answer must be that community law precludes the application of a rule of national law which limits an employee's entitlement to arrears of remuneration or damages for breach of the principle of equal pay to a period of 2 years, if the latter is likely to entail procedural rules or other conditions which are less favourable than those applicable to similar domestic actions. If there was a fundamental proposition of the nature HMRC contend for, that you only have to give treatment with the least favourable similar action, it is impossible to see why the court didn't put that proposition in the answer. That answer is a clear statement that if you can find a similar action that's treated more favourably, you've got a breach of the principle of equivalence. That's what's being said at paragraph 53. The next case is Pontin, which is behind tab 27 and begins on page 943.
So what's this about?
My lady, this is a case where there was a 15-day time limit for a person dismissed whilst pregnant. And that was a 15-day time limit for seeking any remedy. 2 comparators. The first was an action for damages for wrongful dismissal, which on the referral could not be claimed by the pregnant person who was dismissed. And the time limit for that would be 3 months. And the second comparator was an application for a declaration that dismissal was null and void in a case of dismissal by reason of marriage. And there was a 2-month time limit for sending a letter raising the issue with the employer. We get 3 things. The first is another statement of the equivalence principle and the no most favourable proviso, and that's at paragraph 45.
These are all chamber decisions, aren't they?
Yes.
Page.
Page 950, my lord.
Yeah.
Paragraph 45. It encapsulates the law as we've seen it in Leves. The second proposition that we get from Pontin is a further clear statement that there may be one or more similar actions, and if there is, you must compare with each. And that's at paragraphs 55 to 56. So I would emphasize again, paragraph 56, if it emerges that one or more of the actions referred to in the order for reference, or even other national remedies that have not been put before the court, are similar to an action for nullity and reinstatement, it would also be for the referring to court to consider whether such actions involve more favourable procedural rules. Then, in fact, the court itself goes on to carry out that comparison in paragraphs 58 and 59.
It's a bit obvious, really, isn't it?
It is, my lady.
Subject to the proviso that it's for the national court to decide what's similar.
It is, my lady. But what we don't get is any statement that equivalence only prohibits singling out, or only prohibits singling out for worse treatment. That's not there. I say it's contradicted by the fact that you are required to look at all the similar actions, then maybe one or more, and make a comparison with each. And that's what the court itself does at 58 and 59. And the fact that it compares them with both the suggested comparators is pertinent, I say.
So the upshot is you're entitled to the best option.
Subject to the most favourable proviso, which I'll come on to, which, incidentally, if you accept my submissions on EDIS, I can't find any case where that proviso has been applied.
Well, I mean, it's slightly odd because you have a proposition that you have to give them the best possible option, subject to a proviso that you don't. That seems a slightly odd legal concept.
My lord, well, I'll show you what Lord Neuberger said about the meaning of that proviso in Stringer shortly. His lordship said that it means exceptional or unusually beneficial rules. And if that's the case, then it's not at all odd that in the standard run of cases, you will get the best treatment. And in fact, whenever the equivalence principle has been applied, there's never been a search for something more favourable. So you can say, well, this is more favourable, but it's not the most favourable. There's never been that search, which if you apply the proviso in a very literal way, you would expect to find.
Well, you're going to come on to it,
I'm going to come on to that, my lady.
because it's all very puzzling.
In fact, we are going to Stringer next, my lord, and that's tab 5, page 277. And Stringer, although it's a revenue case, it's actually an employment law case. So Mr. Stringer was an employee or former employee of HMRC. It was a claim for holiday pay by employees required to retire after long absence due to illness.
Sorry, what page are we on?
The case begins at 277, my lord.
Thank you.
The time limit for that claim was 3 months from the time of the right accruing. For unlawful deductions from pay, the time limit was 3 months from the last unlawful deduction. So if there were a series of deductions, you could go right back to the beginning, the first deduction, by reference to the date of the last deduction. So that was the more favorable treatment found by the claimant. Lord Walker and Lord Neuberger both dealt with the principle of equivalence, and Lords Hope, Lord Roger, and Lord Brown agreed with them. I can give you the paragraph references. That's Lord Hope at paragraph 1, Lord Roger at paragraph 33, and Lord Brown at paragraph 64. I should also show you paragraph 68, page 298, which confirms that the reasoning in respect of equivalence is part of the ratio of the decision. In my submission, we get 4 points from Stringer. First is the statement of the question of equivalence and what it requires the court to answer, and that's at paragraph 79. So this is the approach to equivalence which I advocate to the court, which is just 2 questions. Are there similar actions? If there are they treated more favorably? That approach to equivalence, I say, is inconsistent with equivalence only prohibiting singling out. Then, my lord, we have the answer to your question as to what the no most favorable proviso means at paragraph 81, on page 301. Now, it is true that at paragraph 42 of Leves, the Court of Appeal does not say exceptional or unusually beneficial rules. The court has never explained what it means by most favorable rules. So this is Lord Neuberger interpreting the equivalence principle.
I said it was all very puzzling because you mustn't single out the EU law action for worse treatment, but you don't have to apply the best treatment. So if you've got 2 similar actions, which is why we're talking about the intermediate situation, you're not obliged to provide the better treatment as between those two, from those two actions. You mustn't provide something worse than the lesser of those, the less favourable of those two comparable actions. That makes sense, but it's difficult to reconcile, which is why I said it's all very puzzling, it's difficult to reconcile with the compare with all the equivalents that you've just shown us.
Yes, my lady. So what does the most favourable proviso mean? I am going to make more detailed submissions on this later.
Do it later.
Do it later.
I'm just telling you why I'm finding it puzzling.
It is puzzling. Well, there has to be a way to square the circle. One way is Lord Neuberger. You interpret the most favourable proviso to mean exceptional or unusually beneficial. Then, in the standard run of cases, you're not concerned with the most favourable proviso. And that would also explain why there is no case that I can find where the most favourable proviso has been applied, and why it isn't a huge issue in every case on equivalence. It's mentioned by the by in most cases, we'll see, but it's never applied.
I mean, the only guidance we get from Europe is from Leves referring back to Edis, is that right?
Yes, my lord. As I said, there is no elaboration on that terminology you've already seen. I will come back to Edis and Leves, because there is a subtle difference in the way they frame the reference to most favourable proviso that could square the circle in a slightly different way to the way Lord Neuberger did. But one has to reconcile the apparently literal meaning of the phrase, no most favourable treatment, with the way it is applied in practice in cases such as Leves, Pontin, and the other cases I'm about to show you. Paragraph 84 contains a caution against looking at the matter too narrowly.
Is this your third point?
That's the third point, my lord. And the fourth point is at paragraph 88, which is a statement that the question of similarity has to be considered by reference to the context in which the principle is being invoked. So similarity depends upon context. And we'll see that picked up by the Supreme Court in the FA Iraq. And FA Iraq is in fact the next case I would like to show the court, and that's behind tab 3, beginning on page 253. This was an attempted appeal against a refusal of asylum claim and humanitarian protection under the EU Qualification Directive. Domestic law only allows an appeal against the asylum decision. The applicant invoked equivalence, arguing that humanitarian grounds were treated less favourably than the domestic law asylum claim. The Secretary of State argued that the asylum claim was not a domestic law comparator because it partially derived from EU law, or in any event, there was no appeal against a decision on Human Rights Act grounds, and therefore equivalence was satisfied. So that actually did raise this issue of, well, what is a domestic law action treated in the same way? Because you had the Human Rights Act ground treated in the same way as the humanitarian ground, but you also had this putative domestic law action in respect to the asylum claim, which was treated more favourably. So we did actually have the treated the same, treated more favourably dichotomy, which we have in this case. And we'll see the Supreme Court did not think that was an answer to equivalence. So I submit we get 4 propositions from FA Iraq. The first is another statement of the equivalence principle, And that's at paragraph 13, page 259. In the very last sentence, this in turn depends on whether FA can demonstrate that there is a comparable domestic right which is subject to more favourable rules than is his humanitarian protection right. So again, that's the same questions as posed in Stringer. Can you find something similar? Is it treated more favourably? There is no further qualification that there must be no singling out, or that you can't have the best treatment, or you get equivalence with the least favourable similar action. Just two simple questions. Is it similar? Is it treated more favourably? And it's worth noting that the court was plainly aware of the Edis case because it cited it at paragraph 28 on page 262. So the court cites the no most favourable proviso from the Edis case, which HMRC rely upon, but it did not consider that to be an answer to the questions before it, which it should have done on HMRC's case. And that is in fact my second proposition, because the issue of what happens if there is a more marked similarity with a domestic action treated in the same way is raised at paragraph 16, page 259. So this issue has a number of aspects, the last of which, if there is a more marked similarity between the community right and a human rights claim, how does this affect the application of the principle of equivalence? So the issue was before the court, it was identified, and then at paragraphs 32 and 33 we can see the parties refer to this human rights claim in argument. So paragraph 32, fourth line down, this is the Secretary of State's argument. It is argued that where there is a far more readily comparable action to the community law claim, such as the human rights claim, the allegedly domestic law refugee claim had even less to commend itself as a proper comparator. So there it's not considered to be a knockdown answer even by the Secretary of State. It's relied upon to guide the similarity question. And you can see that it was answered, or that point was sought to be answered by the respondent in the paragraph 33, 5 lines up. Moreover, the grant of that status carries with it certain benefits, while the human rights claim, which the Secretary of State suggests is a more suitable comparator, does no more than prevent removal. So that the argument was joined on this issue. The court was fully aware that there was a human rights claim treated in the same way. But that didn't answer the question. The court decided to refer the question of how one determines similarity to the Court of Justice. On HMRC's approach, and indeed the Court of Appeal's approach, the Supreme Court got this wrong. The fact that the Human Rights Act claim was treated in the same way should have been a complete answer to the principle of equivalence.
So what was the answer?
The answer was the court wasn't sure about how you determine similarity, my lady.
I realise that. What was the answer to the question referred?
It didn't proceed, my lady. The reference was made, but then for reasons I can't tell you, I don't know, the court never got round to deciding. I believe the reference was withdrawn for some reason. But, my lady, it's notable that the Supreme Court was not referring the question of what you do if you have a similar action treated in the same way. That didn't concern the court. The court didn't think that was an answer. The court was merely concerned, in its reference, with whether the asylum claim, because it derived from both domestic law and EU law, could be considered as a potential comparator, given its EU law pedigree.
Well, also the court referred to the different outcomes. Human rights claim merely prevented removal, whereas an asylum claim and indeed a humanitarian protection claim will both result in getting an immigration status.
That, my lady, is the argument of the respondent. The court...
Exactly so.
Yes, my lady.
Presumably why the court thought that it was worth referring the question of how you determine similarity.
Yes, my lady.
Which I think was the question, wasn't it?
Well, no, my lady, the point being put by the parties is not the human rights claim is not similar. It's just a question of what do you do if something's more similar. So actually, the issue isn't even the same one that's framed before you, my lady, because here the question is, well, if there's a similar action treated in the same way, is that the end of the game? Whereas in the Supreme Court here, the question is, well, do you go on to consider degrees of similarity? And that's the question that was argued and disputed between the parties. No one was saying it wasn't similar at all.
Do we know what the questions were?
I don't, my lady. Perhaps I can look at that over lunch, my lady, see if there was a reference. That's...
Well, it would be quite helpful to know what this court, in this case, thought was worth asking Luxembourg about, even if we don't know what Luxembourg answered.
Yes, my lady.
It would also help us to know just how much of decision there is in this case at all.
It is quite tricky to work out.
How much...
You're seeking to derive some authority from this case, but
Yes, my lord.
all that's said at the very end is that there are a number of issues that need to be considered by the CJEU. So it's not clear whether there really are any decisive conclusions that can be drawn from this court's decision to refer that case.
Well, there is, my lord, because if nobody was arguing the human rights claim wasn't similar, there was an argument over degrees of similarity. Therefore, if the proposition for which HMRC contend is correct, given that you had a similar action, the domestic law human rights claim, treated in exactly the same way, that should have been an answer to the whole case and there would have been no need to refer. So the fact that there was a reference at all shows that the test proposed by HMRC, applied by the Court of Appeal, is wrong.
Not necessarily. It really doesn't
We're
necessarily.
bound by something which wasn't decided. Anyway.
The third proposition is at paragraph 25, which is a clear statement that the aim of equivalence is the elimination of discrimination, and results should be consistent with that principle rather than anomalous. The fourth proposition is that the Supreme Court was not sure what the indispensable requirements for similarity were, and so referred the question to the Court of Justice. And that you can see at paragraphs 40 to 42. those are the propositions from FA Iraq. The next case I would like to show the court is Transportes Urbanos, which is tab 30, page 1025. This was a case involving an unlawful restriction on the right to deduct input VAT. The taxpayer failed to apply to amend its VAT return within 4 years, as it could have done. Instead, after the 4 years was up, it claimed damages corresponding to the VAT. That claim was rejected due to a failure to exhaust administrative remedies, i.e., to try and amend your VAT return. The comparison was an action for damages based on the unconstitutionality of domestic law, which did not require the prior exhaustion of administrative remedies. So that's how the equivalence principle was relevant in this case. What we get is two things. First, another statement of the principle of equivalence and the most favorable proviso, paragraphs 33 to 34. That's 1046. The second proposition I say we get from this case is that the Court of Justice took an approach to similarity and purpose that was broad and inclusive. And you can see that at paragraph 36.
I'm sorry, which paragraph?
36, my lord.
Thank you.
Well, 35 is the statement of principle, isn't it?
And then 36,
Which
the court goes on to apply. Yes, my lady.
35 is the statement of principle which you've already drawn our attention to.
Yes. But what's interesting in this case is how the court applies that principle. Because you have here an action for damages. And the court says, well, is the purpose the same? Yes, it is, because you're seeking compensation for loss. The fact that the loss was VAT did not matter. Focus was on the action, not the type of loss, or indeed the way that loss may be calculated. And it's very easy to imagine that a whole raft of different types of loss would be brought within this principle of action for damages beyond VAT.
This is the Grand Chamber.
It is, yes.
Oh, yes.
How wide is that going? I mean, is it saying that any claim for loss suffered by harm as a result of an act of the state has to be covered by exactly the same rules, whatever the context?
My lord, the question of similarity, as I will submit, is context-specific, which means that you've got to decide similarity in light of the treatment in question. So in that case, the treatment in question was whether you had to exhaust administrative remedies.
Yeah.
And so for the purposes of that particular treatment, the court decided those actions are similar. If the treatment in question was something else, maybe a limitation period, the court might, if there was a good reason, have said they're not similar for that particular purpose. It's context specific. So you cannot draw an endless stream from this particular paragraph and say, well, their compensation for loss is always the same purpose. It depends on the treatment in question. The next case I'd like to show the court is Riemsma, and that's tab 28, page 957. The facts of this case are a little more complicated than the others. There was a claim by a business established in Germany against the Italian tax authorities for repayment of VAT incorrectly charged to it by an Italian taxpayer. So Riemsma had paid the tax, or the VAT, an amount it thought was taxed, to its supplier in Italy, who'd paid it to the Italian tax authorities, and rather than go after its own direct supplier, Riemsma went after the Italian tax authority. Italian VAT had not been chargeable on the suppliers in question because the place of supply was deemed to be Germany. So that's why Riemsma wants its money back. No VAT should have been paid to the Italian authorities. On the contrary, the reverse charge procedure applied such that Riemsma itself was liable for the VAT in Germany. The question of equivalence arose because where income tax was erroneously retained at source by an employer and paid to the tax authorities, Italian law allowed both the employer and the employee to seek reimbursement. But Italian law did not permit Riemsma to make a claim in respect of overpaid VAT. So that's the difference in treatment. And at the outset, I urge the court to note that the very fact that Riemsma's had to go and find this action in respect of employers and employees for income tax means that Riemsma couldn't find a comparator. We can infer with reasonable confidence that it couldn't find a comparator closer to home. So we can infer that indirect taxes were treated in the same way as VAT. It's a very specific comparator that Riemsma's gone for there. I submit we get 5 propositions from this case. First, on page 975, paragraphs 43 and 44, we get the proposition that equivalence and non-discrimination and equal treatment are interchangeable in relation to procedural matters. The court doesn't consider them to be different. And that's consistent with what I've shown you in FA Iraq, where paragraph 25, it was stated that the principle of equivalence is giving effect to non-discrimination. The second point I say we get from Riemsma is that it is a good illustration of the fact that similarity depends upon the nature of the treatment in question. Because on the facts, the court held that the VAT system was not comparable to the direct tax system. And that's at paragraph 45.
And why did they reach that conclusion?
My Lord, there's no reasoning in the Court of Justice decision. It just says in the present case. There's a little more light in the Advocate General opinion, my Lord, at paragraph 94.
94.
Of the Advocate General. I'm just finding the page reference, my Lord. It's page 1000.
Which paragraph?
94, my Lord, page 1000. And this point about the direct relationship is referred to by the court at paragraph 32 of its decision, page 972. But not specifically in the context of explaining paragraph 45, I accept. But what I say the court means, or is relying upon, is that employment income tax is withheld and accounted for to the tax authority in respect of a specific person. At the end of the day, the tax authority needs to know...
As opposed to being as opposed to being returned on a globalized basis.
Which is VAT, my Lord.
Yes.
You don't say...
Why should that make a difference?
In terms of verifying the claim. So the treatment in question is who can make the claim. So Ritzma is saying, I want to claim against you, the Italian tax authorities. The tax authorities in Italy have no idea who Ritzma is. They have no relationship with it. They have no idea how much VAT Ritzma has been paid to its suppliers. Right. Therefore, the Italian tax authorities have no way of verifying that claim. For employment tax, however, employment tax is paid in respect of a specific person. The employer says, I'm paying this much income tax in respect of this employee, etc., etc., and then there'll be a reconciliation later in the year, presumably. And therefore, if the employee says, I've paid too much income tax, the tax authority says, well, I can check because we've been told that this much has been paid, and we can verify that claim. So the treatment in question, who can claim, is directly related to the nature of the tax. And that explains why they aren't comparable in the present case. It is also pertinent, or potentially pertinent, in light of the way HMRC framed some of their submissions, to note that in this case, VAT was the customer's liability, but that did not make it a direct tax, and the income tax payable by the employer did not make it an indirect tax. So even though the employer is paying the tax in respect of the employee, it didn't make it an indirect tax.
Well, the employer's withholding part of the employee's earnings, is that right?
The employer is liable to account to the tax authority for tax on the wages of the employee. Yes, my lord.
Yes, but it's the employee's money that's being used.
Well, I'm going to come on to this a little bit later because I have brought the PAYE regulation, which applies under UK law. But in short, the employee gets the benefit of the deduction for PAYE that should have been accounted for, whether or not it is accounted for.
Well, it only went to the mechanics of collection and not to the liability.
My lord, in terms of liability, the employer is liable. That is the person who HMRC will come after with their PAYE determination and say, you must pay us this. They can go after the employee subject to certain threshold tests.
Yes, but the substance of it is that the employee's liability to tax is being discharged as part of the mechanics of collection through the PAY system by the employer.
Yes, my lord. And HMRC are saying, well, VAT is something similar to that, because they're saying, well, you're collecting tax that you on behalf of the tax authority by charging it to other people. So it's
But that might be a relevant difference, mightn't it?
in my submission, not my lord, but I'm going to come on to that point later, because HMRC say that is a reason for different treatment in the present case, and I'm going to make my submissions on that later. The fourth proposition I say we get from Rietzma is that the Court of Justice did not regard VAT as its own comparator or as having no comparators in any circumstances. It simply said, in the present case, it is not comparable to the direct tax system. Whereas if there was a general proposition of the nature found at paragraph 59 of the Court of Appeal's decision, it is very difficult to see why the Court of Appeal wouldn't have just told us that. You can give up looking for comparators in the VAT field because there are none. And we'll see the same point emerges from Littlewoods in a moment.
The Advocate General comes quite near to saying that in paragraph 94, doesn't he? Because having made the particular point, she says, indeed, the whole system of direct taxation is unrelated to that of VAT.
In the present case, my lord. Well, my lord, if we're going to play off Advocate Generals against each other, I'm going to show you the Advocate General in Littlewoods in a moment, who takes a diametrically different view. In terms of the Court of Appeal, the Court of Justice, it limits itself to saying in the present case. And bizarrely, as you'll see, the Court of Appeal accepted that that's the correct interpretation of Rietzma, but didn't go on to consider whether there was similarity for the purposes of the present treatment.
Well, I mean, the fact that something is similar for a particular purpose does not mean that it isn't similar for other purposes as well. You simply have to look at what the point being made is. And Advocate General Sharpston is making here a pretty broad point about the character of VAT and as compared with income tax in any context. The systems themselves are not comparable because of the different role of the person paying the money.
My lord, one has to interpret the Advocate General in the context of the case before her. Mm-hmm. One has to then look at the Court of Justice, which says in the present case. One then has to look at the Advocate General in Littlewoods, who took a different approach to comparison, and indeed the Court of Justice in Littlewoods, my lord. So, yes, if one confines oneself just to the Advocate General in Rietzma, my case might be a lot more difficult, but actually the Court of Justice itself says we're looking at the present case, and then we go to Littlewoods, my lord, which is where I'm going right now. Oh, well, the fifth point, actually, sorry.
Yes, you had 5 propositions. Could you remind me, your third was, the second was that similarity depended on the nature of the treatment in question.
Yes, my lord.
And I don't know if you enumerated your third.
The third was the point about, on the facts, VAT was the customer's liability, but that didn't make it a direct tax.
That was the third point, yeah.
And conversely, income tax was the employer's liability, but didn't make it an indirect tax. The fourth point...
Yeah, I've got the fourth point.
Fourth point you've got, my lord. And the fifth point, which I was about to forget, but is that the fact that Rietzma relied upon a comparison with employment tax means, logically, that other indirect taxes must have been treated in the same way. Otherwise, presumably, Rietzma would have said, well, I want to rely upon the way you deal with that indirect tax. But nobody thought that was an answer to reliance on equivalence. Whereas on HMRC's case, on the Court of Appeal's judgment, it should have been a complete answer. And we'll see the same point in Littlewoods. Littlewoods is behind tab 22. Begins on page 823. I'm sure this court's aware of the facts of Littlewoods. There was overpaid output VAT on the commissions of sales agents. Simple interest was paid, but Littlewoods sought compound interest, and the general question was posed, does simple interest comply with EU law? I'm going to, if I may, take the court both to the Advocate General and the Court of Justice in Littlewoods. I say we get 5 points from the Advocate General. The first is that member state procedural autonomy is a margin of appreciation rather than a broad discretion, and that's paragraphs 23 and 24. On page 832, my lord. The second point is that equivalence was raised and contested before the court, and that's from paragraphs 32 and paragraphs 42 to 45.
Sorry, the second point is?
Equivalence was raised and contested before the court. HMRC say equivalence wasn't an issue, but the court and the Advocate General clearly thought it was. So paragraph 32.
Yes. And you say 45?
I'm going to take you to those paragraphs in more detail, my lord. They just show that various parties, including the Commission and governments, made submissions on equivalence, which would be very surprising if the issue hadn't been raised and wasn't being contested.
Thank you.
The third proposition is that there is no general rule that VAT may not be compared to direct taxes. And that I get from paragraphs 42 to 45, and perhaps I could just ask the court to read those paragraphs. In fact, it would be useful to read right through to 47, please.
42 to 47.
Yes, my lord.
Do we need 48 as well?
I'm going to come to that, my lord, but yes, feel free to read ahead.
Let's get to what the court said.
Yes, my lady.
Completely impenetrable.
Well, if I may just make my brief submissions on the Advocate General, because if nothing else, they are sort of a counterweight to the Advocate General in Reitsma.
You were in point 3.
Point 3, my lord, is that there is no general rule
Yes.
that VAT may not be compared to direct taxes. And I make that point because nobody before the Court of Justice submitted that. And because the Advocate General says at 47, similarity cannot be answered in the abstract. And in fact invites a further reference if necessary.
Is that not, I mean, the UK government, paragraph 43, does seem to be arguing that there was no comparison between VAT and direct taxes, wasn't it?
Yes, my lord. I suppose, yes, I suppose the UK government does, they say compared to indirect taxes. I suppose that cannot be compared to other taxes then, if I can weaken the proposition slightly, and then the other governments supported the proposition. So there is no general rule that VAT can't be compared to other taxes. That was not supported by anyone before the court, including the United Kingdom, my lord, who said you can compare to indirect taxes. And the Advocate General did not think that there was a universal answer to that question.
But I mean, what about footnote 30 then?
Exactly. So the footnote 30 is confirming what I previously submitted, that you can't decide this in the abstract. You've got to look at the treatment in question and decide, with reference to that treatment in question, is there similarity? And Rietzma is cited as an example of looking at the treatment in question rather than answering it in the abstract, whereas this Court of Appeal decided to answer it in the abstract without reference to the treatment in question. I mean, it's a little odd because the Court of Appeal did accept that interpretation of the Advocate General and indeed Rietzma, but then decided to answer the question in the abstract in any event. So I'll come to that later, but that is what the Court of Appeal appears to have done. The fourth point, the fact that some other domestic claims are treated in the same way does not satisfy equivalence if others are treated more favorably. And you can see at paragraph 36 that the interest under section 78 was computed by reference to section 197 of the Finance Act 1996 and the air passenger duty and other indirect tax interest rate regulations. So other indirect taxes are treated in the same way as VAT, and indeed that's presumably the basis on which the UK government was content to accept that VAT was similar to other indirect taxes in this case. No problem posed, they're treated in the same way.
Sorry, I've been concentrating writing down your fourth point. Where did you get it from?
It's more of an omission than a paragraph, my lord, because nobody thought the fact that other indirect taxes being treated in the same way was an answer to the equivalence point. It's not submitted by any of the parties. It's not referred to by the Advocate General, and we'll see it's not what the Court of Justice says. Whereas if the fact that other indirect tax claims are treated in the same way meant that equivalence was satisfied, it would have been a knockdown answer to any reliance on the principle of equivalence.
Isn't that what the UK government was arguing?
In paragraph 43.
Yeah. It's saying you can only compare it with other indirect taxes, and it's not singled out for worse treatment than other indirect taxes, as paragraph 36 shows. Now, the UK government may not have succeeded, but it seems to have been arguing it. I'd still like to know what the court said.
No, my lady, because they're arguing about can you even draw a comparison with direct taxes, and they're saying, no, you can't. You can't draw a comparison with direct taxes, you can only draw a comparison with indirect
Well, if you
taxes.
can't draw a comparison with direct taxes, only with indirect taxes, and you've got other indirect taxes that are treated the same, that is a knockdown argument.
Yes, but it's a different knockdown argument, my lady, because there could have been two knockdown arguments. The first would have been you can't draw a comparison. The second would have been even if you can draw a comparison, it doesn't matter. There's no need to worry about that question because we treat other indirect taxes in the same way. And my lady, my submission is that
they didn't need to argue that if they were right on the point they made. So the fact that no one argued it, I think, is a point of little weight.
well, my lord, the Advocate General raises a difficult question of what is similar between paragraphs 38 and 48, whereas all of that could have been short-circuited by simply saying it doesn't matter whether it's similar because you treat other indirect taxes in the same way. So, my lord, you may say it carries little weight.
I see the point.
You can see the point, my lady. Fifth point is that the UK did accept, as has already been observed in that case, that VAT could be compared to indirect taxes. That's at 43. Court of Justice deals with equivalence at paragraph 31 on page 845.
Sorry, tab.
Tab 22, my lord. So it's the same
tab.
Just page
further on.
845.
In which paragraph?
Paragraph 31, my lord, bottom of the page.
So the same sort of mantra-like recitation of the principle of equivalence and the principle of no most favourable treatment are put side by side.
Yes, my
This
lord.
time without even reference to the inevitably cited earlier authorities, through which you've taken us.
Yes, my lord.
Yeah.
So the court sets out the principle. It says
And we get
at the very bottom of the page, for that purpose, the national court must consider whether the actions plural concerned are similar as regard their purpose, cause of action, and essential characteristics, and then
Yeah.
it refers to Ponton, which I say just continues the earlier line of case law, whereby you look at all the actions, consider whether they have similarity and more favorable treatment. What the Court of Justice, I have 3 points here. The first is the Court of Justice did not state any general rule that VAT may not be compared to direct taxes. It clearly contemplated that it might be comparable to direct taxes. And the contrast with Rietsma is telling, I say, because in Rietsma, the court directly answers the question, whereas here the court says, well, you need to go away and think about it. If there was a general rule of the kind that the Court of Appeal applies at paragraph 59, the Court of Justice surely would have said so and said, no need to consider equivalence in the context of VAT because it's not similar. The second point is the point I've already made in respect of the Advocate General opinion, and it's a point made by reference to what the court doesn't say, and the court doesn't say that the fact that some other domestic claims being treated in the same way satisfies equivalence. So the court had before it the VAT, the other indirect taxes, and the direct taxes. The indirect taxes were treated in the same way as VAT. But the court didn't say, well, that's a complete answer to equivalence, there's no need to consider similarity. Third, there is no statement that equivalence only prohibits singling out. So that sentence I showed you in Edis at the beginning, and upon which HMRC placed considerable weight, does not appear in this case or in any of the other cases I've shown you.
No statement that equivalence.
Only prohibits singling out.
Yes.
Those are the key cases I wanted to show the court, and they provide the general background to the submissions I will now make on similarity and the effect of there being more than one similar action. Taking similarity first, I accept that if there is no true comparator, the court is not required to simply find the closest alternative. In other words, it is possible that there may be no comparator on the facts of a particular case. My case is simply that appeals against assessments to VAT are similar to appeals against assessments to income tax, etc., for the purposes of a rule requiring prepayment of the disputed tax. That is the nature of my case. The test for similarity was considered by this court in FA Iraq by reference to the Court of Justice authorities. There it is said, or derived from the case law, that one must consider the purpose, essential characteristics, and juristic structure of the allegedly similar cause of action. This court also said there is much to be said for a context-specific approach to identifying similarity. That was at paragraph 42 of FA Iraq. But nevertheless decided to refer that question, or the question of what the indispensable requirements for similarity are, to the Court of Justice. Now, it's possible this court may decide it needs to refer the same questions which weren't answered on what the indispensable requirements of similarity are. However, I submit that the case law on equal treatment confirms that we are looking for context-specific similarity. So whereas the Supreme Court said in FA Iraq there is much to be said for a context-specific approach, I say that the case law on equal treatment confirms that is the correct approach. I may just show you one paragraph of Compass Contract Services to confirm that in the context of equal treatment. That's behind tab 17, page 653. And it's paragraph 25. So, towards the bottom of the paragraph, the elements which characterize various situations and hence their comparability must in particular be determined and assessed in the light of the subject matter of the provisions in question and the aim they pursue, whilst account must be taken for that purpose of the principles and objectives of the field in which the measure and issues relate. So I say that confirms that similarity cannot be considered in the abstract, cannot be considered once and for all in relation to VAT, has to be considered by reference to the treatment in question in this case. So the test for similarity requires one to consider the purpose, essential characteristics, and juristic structure of the cause of action in the context of the treatment in question. I am asking the court to compare an appeal to the first-tier tax tribunal against an assessment to VAT, not a claim for overpaid VAT or something like that, which the Court of Appeal appears to slip into thinking it was dealing with at various points, an assessment to VAT, a demand that VAT should be paid to HMRC, against I compare that to an appeal to the same first-tier tax tribunal against an assessment to income tax, or to capital gains tax, or to corporation tax, or to SDLT. In terms of the purpose of that cause of action, which is the appeal, the purpose is precisely the same. It is to challenge HMRC's view as to the correct amount of tax and obtain a binding view from an independent and expert tribunal. That is the purpose of an appeal against an assessment to VAT and an appeal against an assessment to income tax. It's the same. And in that respect, I remind the Court of the approach of the Court of Justice to purpose in transportes. The Court took what I say is a relatively high-level approach to determining purpose. The purpose was the same because they were both seeking compensation for loss. It did not matter how that loss was calculated, and on the facts, it was actually VAT that was being claimed. So that's the purpose. The next question is the essential characteristics of an appeal to the first-tier tax tribunal. And in my submission, they are exactly the same whether the appeal is against a VAT assessment or, for example, an income tax assessment. The appeal goes to the same body, the same rules of procedure apply, which are specific to tax appeals, the same judges. There is no difference between the essential characteristics of an appeal against a VAT assessment and an appeal against an income tax assessment. The only difference is this hardship rule. Third, you have the cause of action. And I say, or I submit, that it is the same. In each case, it is an argument that the payment of tax demanded by HMRC is not due under the relevant tax legislation.
But if you put the cause of action at that level of generality, why is it an EU law claim at all?
It's an EU law claim, my lord, because it's giving effect to my client's EU law right to deduct input VAT. I mean, that point is not in dispute, my lord.
Well, no, but I'm not sure that the level of generality at which you put the comparison is beyond dispute.
Well, if you go back to transportes, my lord, there
Yes.
the cause of action was an action for damages based on either the unconstitutionality or the breach of EU law by the state through its act or omission. So in terms of generality, that is the general level at which it was taken in that case. When one comes to tax appeals, it's a little bit odd to think of it as a cause of action in the sense that one might think of a contract or a tort claim as a cause of action. But nevertheless, if one's trying to do one's best to apply that concept, what is the underlying argument? What are you saying? What facts are you saying exist that entitle you to a remedy? Well, you're saying that the tax demanded by HMRC is not due under the tax legislation. That has to be your cause of action. I'm not sure, my lord, what sort of more specific level of generality HMRC might rely upon, but I'm no doubt find out in due course. The only difference, besides the hardship rule, are the rules according to which tax is calculated or determined. So in a VAT appeal, obviously you'll go after the VAT legislation. In an income tax appeal, obviously you'll go after the income tax legislation. bearing in mind that similarity must be judged by reference to characteristics that are relevant to the treatment in question, my submission is that that is an irrelevant matter. It is irrelevant to the question of whether tax should be prepaid before the appeal is entertained, how the tax is calculated. What the law is, whether you pick up the orange book or you pick up the yellow book with the income tax in. And again, that's similar to the Transportes case. The measure of loss there was calculated by reference to VAT. But in most other cases, it wouldn't be calculated by reference to VAT. It could be calculated by reference to any manner of different losses that might arise and be caused by the unconstitutionality of a piece of legislation. That is my positive case on why we have similarity. I'm now going to take you to the Court of Appeals reasoning and set out my criticisms of that. And that's in the appeal bundle, beginning at page 95, but the specific passages I would like to, tab 7, beginning at page 95. But the passages I want to show you begin at page 106. So I have 7 specific criticisms of the Court of Appeals reasoning. At paragraph 52, the court says, "It is also in my judgment clear that the same kind of charges or due," that wording from Edis, "is a subset or a further restriction on similar action, and that restriction means that it is not general appropriate to look for similarities across different types of sectors or tax. There could be many reasons for this restraint." And then the court goes on to address possible reasons at an abstract level. And then at paragraph 59, we find the actual conclusion. "For all these reasons, I conclude that the equivalence principle does not have the effect that VAT has to be compared with other taxes." Now, it's quite odd phrasing, saying has to be compared, as if someone's compelling the court against their will to do a comparison, where it should be voluntary if required. But that is the general conclusion, that we just cannot draw a comparison between VAT and other taxes. That sits oddly, in my submission, with paragraph 58, where the court addresses Rietzma. And if I could just ask this court to read paragraph 58.
Well, bear in mind that we have already read this.
My lady, and I'll take the point as read then, and it's the contradiction between, on the one hand, recognizing that there is no unvarying rule, that one has to consider the particular context of the case by reference to Rietzma and the Advocate General Littlewoods. That is not what the court did. Instead, it considered the matters in the abstract and decided that you cannot compare VAT for various reasons suggested between 52 and 54. The second criticism is that if the unvarying rule the Court of Appeal applies at 52 and 59 does exist, it's impossible to see, in my submission, why the Court of Justice did not state that absolute proposition in either Rietzma or indeed Littlewoods. My third criticism is that the Court of Appeal decided that VAT was not comparable to direct taxes by looking at matters in the abstract rather than with reference to the treatment in question. So if I can direct your attention specifically to paragraph 53, what domestic law action is similar to an action to recover overpaid VAT? Well, pause there, I'll come back to that. This is not an action to recover overpaid VAT. Mr. Firth submits that the court need only look at the characteristics of the action which are relevant to the issue before it. That's true. He submits that income tax and SDLT are similar because they also go to the FTT. Well, that's not the entirety of my submission, but nevertheless, going on, I do not consider that this is the right test. And then you can see in paragraphs 53 and 54, the court considers general points about VAT.
Is this really an expansion of your first point?
My first point was the court contradicted itself, which is a sort of a separate reason for not being satisfied.
But you also said that the court considered matters in the abstract.
Yes.
Yes, but
It develops that point, my lord, yes. The fourth criticism is that the Court of Appeal did not consider the purpose, essential characteristics, cause of action, or juristic nature of an appeal against a VAT assessment. If you look through paragraphs 52 to 54, you will see the Court of Appeal just does not address its mind to those questions. What is the purpose of a VAT assessment appeal? What is the cause of action? What are the essential characteristics of the appeal? Instead, the court preoccupied itself with looking at what VAT is as a tax at an abstract and general level, and that, as we can see from the authorities I've shown you, is not the right test. As a consequence, and this is my fifth point, as a consequence of not looking at the matter with reference to the treatment in question and looking at matters in the abstract, the court gave no reason why prepayment should be a condition of an appeal against a VAT assessment, but not an income tax or an SDLT appeal. And this goes back to my very first point, one of my very first submissions, which is a person may receive in the post on the same day two assessments, an income tax assessment for the amount net of VAT and the VAT assessment for the VAT. And they can be in respect of the same expenditure for the same reason. Why, this man may ask, or this woman, do I have to pay the VAT before my appeal will be entertained, but not the income tax?
If you put the question in that way, and the appeal is about input tax,
Yes.
one difference that strikes me quite forcibly is that with the VAT, you've already collected the VAT from your downstream purchaser or consumer, whereas with income tax you hadn't. That might, as a matter of abstract common sense, justify a rather tougher attitude towards depositing it before you appeal.
My lord, first of all, input tax is not tax that you collect downstream. That's out.
No. I'm sorry. I didn't mean that. If the appeal is about whether you're entitled to deduct input tax, but you have collected the output tax, you are sitting on tax that's been paid to you by the consumer downstream.
In most cases, clearly.
Yes, I'm not saying in all cases.
Not in the case where you are selling on to someone who will not be paying VAT, i.e. someone overseas. But in the normal case, as Lord Briggs says, the issue of input tax will arise when you have already collected from the consumer or the person next up the chain the output tax, which you are obliged to account to the Inland Revenue, to HMRC.
By definition, that must be wrong, because if my position is that I'm not liable to VAT, I ought not to have charged my customer the VAT and therefore have not collected. So the dispute, so if there's a dispute with HMRC about whether tax is due or not, I say I'm not liable to VAT on this supply. HMRC say, yes, you are. And then HMRC raise an assessment. If my view is that I'm not liable to VAT on this supply, I have not charged my customer the VAT. And I have not collected VAT from my customer because my view is I'm not liable to VAT on that supply.
Well, that may be a particular appeal. I'm not saying every VAT appeal will necessarily arise where you have already collected the input tax, but as output tax, but in the norm, one might expect that to occur.
My lord, I find that difficult to conceive. If the dispute over output tax arises, the two views must be HMRC saying output tax was due, and the taxpayer must be saying output tax wasn't due. If output tax isn't due, then why would I be collecting output tax that I don't think is due?
You may collect the output tax, but you say you have a claim to deduct some input tax, and the dispute between you and HMRC is about your deduction of the input tax.
Yeah.
Yeah.
And that's a very common type of VAT appeal.
Oh yes, my lord, and in fact that's this appeal, but I was just dealing with the first question, which is whether I have collected output tax. You wouldn't in an output tax appeal. In an income tax appeal, the question is, well, if I've paid that money away as expenditure, and that's where the input tax arises from, then I don't have the money anymore. That's what
You either have collected the output tax, or the law says you should have done, though you didn't. So it's not altogether irrational.
But this is
to proceed on the basis that you've got it.
But we're confusing two different types of assessment. This is an input tax assessment. So what's being assessed is input tax. It's not an indirect way of collecting output tax. It's input tax. So in the output tax context, the dispute will be, was it due or not? Logically, I shouldn't have collected it if I say it's not due. So therefore, I'm not sitting on the money. In the input tax situation, I say I've paid this money away as input tax to my supplier. And you say, well, you can't have a deduction for that. But logically, the money's gone. I'm not sitting on the money.
Can I put it in these general terms that I hope this isn't a misstatement, but the essential structure of VAT is that the burden of the tax ultimately falls on the consumer, and it's collected for the revenue by people up the chain, and it's they who have the disputes with the revenue arising in VAT appeals, so that your taxpayer is in a VAT situation in the nature of a tax collector from others, which he isn't in an income tax situation.
Well, there's two answers to that. One is the PAYE point, which I've touched on and we'll come back to. The second point is, as a general proposition, that's not quite right about the structure of VAT. If I can take you...
I'd put PAYE on one side.
This is VAT point, my lord, and volume 5 of the
in
authorities
general.
bundle, which should have been on your desks this morning. And on page 4 of the volume 5, we should have the Value Added Tax Act,
Yes.
section 1. And you can see from section 1, subsection 1, value added tax shall be charged in accordance with the provisions of this act on 3 things. There are 3 separate kinds of VAT. The first is VAT on the supplies of goods and services. Second is VAT on acquisitions. That's goods coming from other EU countries into the UK. And the third is on the importation of goods from places outside the member states.
But what we're looking at, surely, is whether there is a difference of economic substance rather than of legal form. Economically, the whole economic basis of income tax is different from the economic basis of VAT, whoever the revenue may, by statute, be entitled to go against.
It's a very general proposition, my lord. I'm not sure
Indeed
what's
it is.
packed within it. So if I may just, rather than accept it wholesale, if I may say that we are looking at the question of prepayment. And the questions raised relate to, well, are you sitting on the tax? And that I can see might be relevant. But if you go to an income tax context, accepting there are different rules and it's a tax on income rather than expenditure, if HMRC are right that you've had that income, logically you're sitting on the tax. In the same way that in the VAT well, in fact, it's actually different in the VAT context. In the VAT context, if I say my supply is not liable to VAT, I should not be sitting on the VAT because I should not have charged it to my customer. So
And there are no circumstances under PAYE, are there, when you can have collected the tax from the employee and not be liable to account for it to the Inland Revenue? That's a question.
If you deduct too much tax from your employee's wage packet,
Yes.
then you don't have to account for the
Then you
revenue
have
from
to
the
account
excess.
to it for the employee rather than the revenue. But one thing you can't do is sit on it.
You shouldn't.
Well, indeed.
If you've deducted tax that is properly due, then you have to account for it in accordance with the PAYE rule, my lord, yes. And it's the same with VAT. If you charge VAT, then you have to account for it.
Well, that depends on how much set-off you've got of the input tax.
Well, a credit for input tax does not mean you are not counting for your output tax. It just means you're getting a credit for input tax.
Exactly.
So you've
And
still
you're
accounted
accounting for the difference.
you've still accounted for the output tax in the same way that the employer would account for the PAYE.
I think you're looking at this on a rather technical and mechanical basis.
My lord, the issue raised is are you sitting on the tax? And I can see why that might affect a prepayment rule. In the income tax context, as I said, if HMRC take the view that you have received income, then logically you must be sitting on the tax because the tax is a proportion of that income. In the VAT context, if it's an output tax appeal, and you're saying we weren't liable to charge VAT, you won't be sitting on the tax because you won't have charged it. If it's an input tax appeal, then you ought logically have to pay this money away. That's how input tax arises. You pay the money away to somebody else. So logically, you're not sitting on the input tax. So in terms of am I economically in a better position to pay a VAT assessment than an income tax assessment, the answer is no. If you have received the income, you should have the money. If you should have charged VAT but didn't, you won't have the money. But the point I was making by reference to Section 1 is that it's actually 1/3 of the VAT system, this tax on supplies. The other 2/3 are acquisitions and importations. And in both of those cases, it's the person who makes the acquisition or receives the importation that is liable for the tax. So this idea that VAT is all about passing it on down the chain doesn't apply to a simple acquisition or a simple import. You acquire the goods, you pay the VAT. If you go to Switzerland and buy some diamonds and bring them back to the UK, you have to pay the VAT on that import. I was addressing my criticism of the Court of Appeal's reasoning. I anticipated a substantial part of what would have come later on HMRC's case that they've raised in this court. My fifth point, which we've just dealt with, was the Court of Appeal itself gave no reason why prepayment should be a condition. My sixth point was that's not surprising because the Court of Appeal was considering the wrong type of domestic action. If you look at paragraph 53, it begins, what domestic law action is similar to an action to recover overpaid VAT? Well, that's not this case at all. This case is a VAT assessment, not a claim for overpaid VAT. And that's not a one-off slip, because if you read 54, it's got the same error in it. And that's not a small omission, because in a claim for overpaid VAT, there's no question of prepayment of tax pending dispute. You claim something from HMRC, they've refused it, you go to the tax tribunal and have an argument. So it wasn't a mistake with no consequences. And then my seventh point is that none of the suggested differences between 52 and 54 have any bearing on the prepayment of disputed tax pending an appeal. And I've dealt with that in my skeleton argument at paragraph 54. I'm not going to repeat those points now because it seems the point that this court is focusing on is the question of, well, are they economically different? Are you sitting on tax? And that's the point HMRC raised in their skeleton argument. So I do refer you to paragraph 54 of my skeleton argument for answers to what the Court of Appeal is saying there. And I'm happy to deal with them now. Report.
No, move on, please.
Turning to HMRC's case, On similarity, HMRC say first this court should follow the High Court in Marks and Spencer's 1999, Mr. Justice Moses, and Littlewood's in the Court of Appeal in 2015. The effect of those decisions is that VAT can only be compared with itself. Well, I've already made extensive submissions on why that proposition is contrary to the Court of Justice and the Supreme Court authorities. I'm not going to go through that again. But there's a further fundamental error in Mr. Justice Moses' judgment, because that case subsequently ended up before the Court of Justice twice. And on the second time, in 2008, Mr. Justice Moses' belief or conclusion that there could be domestic law VAT claims outside of the principles of EU law was found to be wrong. And that's behind tab 24 in the authorities bundle. If I can just quickly show you one paragraph of that decision. Because HMRC asked, well, why do I say that that case is wrong? This is the same submission I made to the Court of Appeal, and you'll see it referred to by Lady Justice Arden on a number of occasions. The reasoning is wrong in respect of the nature of domestic claims. There are none. And behind tab 24, page 883, and it's paragraph 36.
Paragraph 36.
Of the Court of Justice on 883, yes, my lord.
And what's the point you get from that? Sorry.
The point from that, my lord, the reasoning of Mr. Justice Moses in M&S and in Littlewood in the Court of Appeal is, well, VAT EU law claims can be compared to VAT domestic law claims. They're treated in the same way, therefore there's no problem from equivalence perspective. The point is that there's no such thing as a VAT domestic claim, because all of VAT operates subject to the general principles, and therefore even these so-called VAT domestic claims are captured by the principle of equivalence and protected by it. Therefore it cannot be a comparator.
And you say that's what 36 says, does it?
No, my lord, 36 confirms that the domestic law, or so-called domestic law VAT claims, are subject to the general principles of EU law. If that is so, they are subject to the principle of equivalence, and you cannot rely upon a comparison with another cause of action protected by equivalence. To put the point in practical terms, if I had a VAT domestic law claim as considered by Mr. Justice Moses, in that case as well, I can go out and rely upon the principle of equivalence because it is protected by the general principles. So if I can go out and rely on equivalence in that case, it cannot be the comparator for EU law VAT claims because they're both protected by equivalence. It's all within the same bubble. The same point was made by, well, the same point about the general principles of EU law capturing the entirety of VAT law was made by this court in Pendragon. And I'll just give you the reference for that rather than take you to it. It's tab 10, page 468, paragraph 29. The second point HMRC make is that VAT requires a trader to pay over a tax on consumption that has been paid to him. And this is the point that's already been raised by the court. I'll briefly summarize my submissions on this and then see how HMRC develop it in their submissions. The first is that it's wrong for the reason I've already given. If the trader believes VAT is not chargeable, logically he hasn't charged VAT and is not sitting on it. The second point is that in any event it's wrong to say that there is a general rule about who is liable to pay VAT. I've shown you the acquisition and the import VAT. It is the acquirer or the importer rather than the supplier who is liable for those forms of VAT. And the third point is to compare with PAYE determinations. And within the bundle I just showed you, bundle 5, over the page again, on page 5, we have regulation 80 of the PAYE regulations. This regulation applies if it appears to HMRC that there may be tax payable for a tax year under various regulations by an employer which has neither been paid to HMRC nor certified by HMRC under those regulations. So this is how HMRC collects PAYE that should have been paid but is not paid. And the important point is paragraph 5, a determination under this regulation is subject to parts 4, 5, 5A, and 6 of the Taxes Management Act, assessment, appeals, collection, and recovery, as if the determination were an assessment and the amount of tax determined were income tax charged on the employer. That means that the same rule in section 55 about postponement applies to PAYE assessments. It also means that there is no rule requiring prepayment of the tax before an appeal against a PAYE determination will be entertained. Now, the point made is that VAT, well, the supplier is collecting tax from another person on behalf of the revenue and paying it over to the revenue. Well, that is exactly the same economic structure, in my submission, as a PAYE situation. The employer collects the tax from another person, the employee, and pays it over to the revenue. So if the reason, or the alleged reason for this prepayment rule is whether you're sitting on the tax or not, why are PAYE determinations not subject to this rule? On the contrary, in my submission, this alleged purpose of the distinction is not borne out by reality. It's not the reason. It can't be the reason because it doesn't explain the facts. And in fact, if we please turn up page 79 of the appeals bundle, which is HMRC's case, behind tab 6. We see HMRC's submission in paragraph 42 on the purpose of the prepayment rule. And the purpose isn't you're sitting on the tax. The purpose is this. The purpose of requiring the payment in advance of the disputed tax is the obvious one of preventing the abuse of the appeal mechanism as a means of putting off payment. The effect in some cases might be to stifle a meritorious appeal when the intending appellant is unable to pay and the hardship provisions are designed to counter that possible effect. Well, that purpose that HMRC rely upon applies equally to income tax, capital gains tax, corporation tax, SDLT. There is no difference between those two different appeals in terms of whether you want to prevent abuse of the appeal system.
Well, the difference may be this, that there are some economic contexts in which it's more objectionable than others. This goes back to the sitting on the tax point. It may be regarded as more objectionable to abuse the appeal system in order to obtain the benefit of sitting on tax than it would be if you were paying effectively your own tax.
This sort of strays into the question of proportionality then. If what you're really trying to get at is cases where the person is sitting on the tax, then the test of hardship and prepayment is far too blunt, because there's no reason why a person with a VAT assessment is necessarily sitting on the tax. And equally, or conversely, a person with an income tax assessment may just as likely be sitting on the tax. So in terms of, is this rule fit for purpose, the answer would be no, if that was the purpose, if that's the distinction.
But is there a logicality underlying the first sentence of Judge Bishop's statement of the purpose? I think you said that in VAT, as in direct taxes, merely appealing doesn't stop the revenue collecting the tax.
That's correct.
And if that's right, why is there scope for an abusive appeal mechanism as a means of putting off liability to have to pay the tax?
It's a good point, my lord. that does
I'm just
undermine.
not sure. With respect, I'm just not sure he's right.
My lord, but take that.
I say that with diffidence in view of who it is.
Take that. Yes, take that further, though, my lord. If the result of the hardship point is if you can still collect the tax irrespective of hardship, then what's the hardship rule doing? HMRC can decide on a case-by-case basis, do we want to collect this tax?
I'm not so much looking at the second half of what he says. I'm
Yep.
looking at, I can quite see that the hardship principle deals with the danger that the requirement to pay the tax up front may stifle the appeal.
Yep.
But what I'm questioning is why the launch of an appeal is a means of putting off payment of the tax if the revenue can collect it anyway.
Well, I suppose it's this, my lord, because if you don't appeal, that's the end of the game. Even if you might have had a reasonable argument as to why the VAT's not due, if you don't appeal in time, then frankly that's game over.
True, but it's not an abuse. If the only way in which appealing prevents the revenue collecting is that you have to have sufficient merit in your appeal to withstand either a winding up petition or to get a postponement direction from the FTT, neither of those appeals will be abusive appeals.
Yes, my lord. Which leaves then a hole as to what the purpose of this hardship rule.
Well, no, with respect, it seems to me that the second half of what he says makes perfect sense.
Well, the second half does make perfect sense, but in terms of you've got to take the two parts of the rule together, prepayment and hardship. And then the HMRC is saying, well, there's a good purpose of requiring prepayment, and it's this. It doesn't matter if you've got a good reason for your exception to the main rule. The question is whether you've got a good reason for the main rule. If there's no good reason for the main rule, it doesn't really help you that you've got a good reason for your exception to your main rule. I'm sorry if that's not...
No, that makes a lot of sense.
Anyway, but you're questioning the first sentence of Judge Bishop's statement there, are you?
Well, my starting point was that would apply equally to any appeal.
Yeah,
my lord
your
pointed out.
point about the first bit is that, well, if that really is the purpose, well, then it applies equally to
Yep.
other appeals.
Yep.
Yeah.
My lord was simply questioning whether that was an accurate statement of the purpose.
My lord may well be correct in that, although, as I said, it is a necessary condition of holding out that you have an appeal. That is what I wanted to say about similarity, subject to the court having any questions. And I've got to go on then to more than one similar action, but I note the time. This may be a convenient moment to pause for lunch rather than have 4 minutes on the more than one similar.
And no doubt you'll have about 9 points on that.
3 rather longer points, my lady.
Very well. Well, we will accept your suggestion and look forward to hearing from you further at 2:00.
Thank you, my lady.
Court is now adjourned.